Say it again, say it again.
Every day just gets sweeter. And I love more.
Hi.
I couldn't take it. And won't let go. Y'all ready for this?
Every day you get much better to me. Every day it get much better to me. And every day you get much sweeter. To me. And with my whole world I love you always. That I'm and with my whole world I love you always. Greetings, 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 greetings to you all. I am King Clifford Jefferson, descendant of Godfrey the Fifth Caliban Jew, son of folk, ruler of Jerusalem. It is August the 30th, 2025, what would be equivalent to the birth year 2975. I greet you in the name of King Edgar our Jesus Christ, or the Vicar of Christ, or the Good Shepherd. This is another marvelous lesson that is going to be a reiteration of the marvelous lesson that I gave prior to this, which is called Part 2 of the Revolutionary Breach of the English Legal Continuity of our Crown. Okay? Particularly saying that it's Part 2 of the Revolutionary Breach of the English Crown Legal's Continuity. Once again, a revolutionary breach in the English Crown legal continuity. This is Part 2 that you will not want to miss. Give me a second. Greetings to you all. Unfortunately, I had to download YouTube. I get on my phone because my grandson erased it, so unfortunately I'm not able to see my comments at this point in time. I have to look at it a little bit further. Hopefully I'll get some clarity on that, but nonetheless, let's get started with this marvelous lesson. This is Part 2 of the Revolutionary Breach of the English Crown's Legal Continuity. Okay? Very important in our flight to regain which was lawfully ours. Okay? In regards to that promise from our Lord and Savior. Okay? This particular inheritance was bequeathed upon trustees who were supposed to be administering the trust on our behalf uh, uh, pursuant to our emancipation underneath what we call the 13th Amendment, which ushered in our inheritance under the 14th Amendment, which was stolen by the Fifth Amendment, okay, of the United States Constitution. All right, very important you understand that. In lieu of Part 1, in respect to Part 2 of the Revolutionary Breach of the English Crown's Legal Continuity. And with that, we get started with this beautiful lesson. Hold it thought. First, let's examine again the 14th Amendment and its intent. Okay, let's examine the 14th Amendment and its intent from a legal, legislative intent, and a president's intent. All right, based upon the common law. All right, first let's just look at that because, a lot of us have a hard time understanding, you know, this problem that we're in regards to our emancipation from slavery. Okay, so we really must take a good look at that. I'm going to take my gun again today, as I always do, and hopefully some clarity will come forth from this light that I'm giving you. Okay. Okay. From Cornell Law School, 14th Amendment. I hate this phone. All right. 14th Amendment. The 14th Amendment addresses many aspects of citizenship and the rights of citizens. Most commonly used and frequently litigated, the phrase in amendment is the equal protection at law. So the purpose and intent for the 14th Amendment is for the rights of citizens and their equal protection at law in regards to that citizenship as established by the 14th Amendment, excluding all those articles and amendments that existed prior to that because they don't apply to this, because at that time we were in fact property. Okay? We were in fact property. First section of the 14th Amendment says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of a citizen of the United States, nor shall any state deprive any person of life, liberty. If I'm showing you this, hold on. Let me share my screen. I thought I was sharing it. Hold on. Okay, here we go. I apologize for that. Let me see if it pop up. Yeah, we good. Give me 1 second. So for the 5 of you that's watching here today, the 14th Amendment addressed specifically many aspects of citizenship and the rights of those citizens. All right? Specifically and exclusively and inclusively those identified as black people or African Americans. Okay? But the application of the 14th Amendment and its sections that does not adhere to the identity of black people or African Americans. Okay? As a result of where the 14th Amendment stems from and its application according to the law. Because when you look at United States versus Joachim Ark, and it also applied to Joachim Ark, which was not a national, he was a naturalized citizen by going through some formal process. That's very important to understand because the rights and protections of the citizenship is different from a national, okay? All right, a person that's born and it's linked to the inheritance of the mother and father who was also born on that soil. Okay, very important. Section 1. 14th Amendment excludes everything from the 13th Amendment and all the articles on which the 13th Amendment sprung from. The 14th Amendment was a new creation of government, inclusively and exclusively for the people that were emancipated by the 13th Amendment. And they were not, my brothers and sisters, African or black people. Okay? That's something that was thrown into the mix. Okay? Something that was clearly thrown into the mix. All persons born, meaning us, all right, nationals, or naturalized in the United States, so they're only talking about two groups of people. We the people, in the preamble that was talking to God, that promised, didn't give it right then, but promised an inheritance to the people, okay, that was already there, okay, on that land. And that promise of the inheritance was supposed to be preserved from generations to generations to generations to generations to come up until this point in time. Okay? One thing we must realize that all those people that were or had a communication with that God had spoke the same language. That language, according to the preamble, was the English language. So that means that anybody speaking a language other than English cannot understand what's being said to them. Okay? So whether you were there or not, it does not include you. Okay? Especially dealing with the protection of a citizen that sprung from the First Amendment. All right? Because the First Amendment is religious freedom. Article 1 is the Establishment Clause that deals with religious freedom. Okay? That's very important. So it says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, of the states wherein they reside, meaning that those states which make up what you call the United States, prior to them being identified as states, they were in fact called colonies. Okay? No state, or it should be better befitting to say, no colony should make or enforce any law which shall abridge the privileges or immunities of a citizen's, would make better sense to say subject, because citizens didn't come until after the states created their citizenship based upon their citizenry. Okay? So no colony shall make or enforce any law which shall abridge the privileges or immunities of the subjects of those territories prior to they be called the United States, nor shall any colony deprive any person of life, liberty, or property without due process of law, nor deny any person within the jurisdiction equal protection of law according to the 14th Amendment. The 14th Amendment and all the sections of the 14th Amendment is from 1 to 5. Okay? From 1 to 5. Section 2, Section 3, Section 4, Section 5 will not apply in lieu of Section 1 if you don't understand the purpose and intent of the 14th Amendment. The framers of the Constitution understood the intent of the 14th Amendment as a result of what took place prior to the creation of the 14th Amendment, which was the creation of Article 1 through 13, which at that time, everyone said we were property. get a closer look at the 14th Amendment. The United States versus Juan Kimahart. This is the legal precedence to support why the 14th Amendment was actually implemented. United States versus Juan Kimahart. Okay? The case was explaining the difference between a national and a naturalized citizen. This is what this case has done. So if you're a naturalized citizen, then your right as a citizen is based upon Article 1 through 13. And Article 1 and the amendments that go from Article 1 to the 13th Amendment, okay, which excluded people who were at that time slaves. And for the sake of a better term, I don't want to say African or black people because you were not African or black people based upon the legal precedence, okay? All right? This United States case versus Juan Kimahart had nothing to do with the claimants, all right, which was a Chinese person, all right? For other references under the common law, you can look at Imre Amaha Hassan, United States versus Singdu or Kingdu, as well as this case, United States versus Juan Kimahart. United States versus Juan Kimahart is a landmark decision of the United States Supreme Court. Now, don't lose in fact that they're not talking about African American or black people in this case, okay? But United States versus Juan Kimahart was a landmark case to clear up the understanding about citizenship and citizen rights under the 14th Amendment, okay? So just read it. United States versus Juan Kimahart is a landmark decision of the United States Supreme Court which held that a children born in the United States of parents of Chinese descent who at that time of his birth are subject of the Emperor of China but have permanent domicile and residence of the United States are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China automatically became United States citizens by way of birth. Okay? But that's naturalization, not naturalization. They're not dealing with that argument. This is what Trump has bringing up in Executive Order 14160. Okay? Totally different argument. Okay? Juan Kimahart was the first Supreme Court, the first case to decide on the status of children born in the United States to alien parents. The decision established an important precedent in its interpretation of citizenship clause of the 14th Amendment to the Constitution. All right? The 14th Amendment to the Constitution. We must understand that. What is the holding? That's what we need to understand. In spite of what was going on with Juan Kimahart, or any person for that matter, we must not lose sight of the holding of what the dissent was according to the justices. Okay? One was a child born in the United States to alien parents is a citizen in the United States. B, the phrase subject to the jurisdiction thereof should be interpreted in the light of the common law. That's key. If it's not interpreted in the light of the common law, then you're put in the category of a naturalized citizen versus a national. Okay? Because in light of the common law, it deals with the nationals that had some type of allegiance to that country as a result of their right of that status, which is called the political status, versus your civil status, which United States Roman Criminal Art. We'll clear that up in a second. Okay? You have two statuses: your political status and your civil status. You got your civil status now as a result of how they identify you in regards to how they identify the Chinese Roman Criminal Art. Okay? But they improperly identified you based upon the parameters of the 14th Amendment, Section 1, Section 2. All right? Section 2 is key, especially when you looking at subjectivity to the jurisdiction thereof in lieu of or in light of what we call the common law. Okay? I hope that makes sense to you all. He challenged the governmental refusal to recognize his citizenship, and the Supreme Court ruled in his favor, holding that the Citizenship Clause should be interpreted in light of the common law. The case highlighted disagreements over the precise meaning of one phrase in Citizenship Clause, namely the provision that a person born in the United States who is subject to the jurisdiction thereof acquire automatic citizenship. Okay? Let's go a little bit further in lieu of the interpretation of the 14th Amendment. The Supreme Court majority concluded that this phrase, referring to being required to obey the United States law, on this basis, they interpret the Citizenship Clause of the 14th Amendment to grant citizenship to children born in the United States with only a limited set of exceptions based on the English common law. So English common law and common law is totally different, because precedents based upon a new government, based upon the judiciary and their interpretation of law, that might not refer to the people of English descent, which was the purpose and intent for the whole 14th Amendment, which was supposed to be construed to the common law. They ain't gonna tell you that in Wikipedia. You got to go to the actual case to get that. All right, which we'll go to in a second. Here we go. The court held that being born to alien parents was not one of those exceptions. The court dissenters argued that being subject to the jurisdiction of the United States meant not being subject to any foreign power. That is, not being claimed as a citizen by another country via what? Jus sanguinis. Hear that, brothers and sisters? You have a birthright as a result of jus sanguinis, an inheritance citizenship from your parents, what would be your ancestors, an interpretation which, in the minority view, would have excluded the children of foreigners. Hold that thought. Sorry about that. Important phone call. Okay. So it's not being claimed as citizenship by another country via just sanguineous, inheriting citizenship from a parent. Okay? That's just sanguineous. That is what we have pursuant to the 14th Amendment. Okay? An interpretation which, in the minority bill, would have excluded the children of foreigners. So if you're a foreigner, then you cannot inherit a citizenship via just sanguineous, which is an inheritance. Okay? We must understand that. Early history of United States citizenship laws. Throughout the history of the United States, the dominant legal principle governing citizenship has been jus soli. The principle that births within the territorial limits of the United States confers automatic citizenship, excluding slaves before the American Civil War. Although there was no actual definition of citizenship in the United States law until after the Civil War, it was generally accepted that anyone born in the United States was automatically a citizen. So prior to the 14th Amendment, we were property, brothers and sisters, straight up property. All right? When we were emancipated, everything that they took from us when we were slaves must be returned to us as a result of the emancipation. It's called the right of redemption. Okay? As heirs, though, just sanguineous, because it's inheritable. If you don't identify with just soil, which is just sanguineous, then you're going to identify with what they call just being naturalized, okay? Just soil and just sanguineous. You're being born on the soil, but don't make you a citizen, okay? Just soil, just sanguineous is two different status that we must understand in regards to one civil status and the other one is the political status, okay? Very important. So let's go to the actual case law to identify what it is that we're reading from Wikipedia. The Constitution, this is United States versus Juan Kim Ark, okay? 169 U.S. 649 1898 case of Justicia, United States Supreme Court, okay? So these are not my words. The Constitution nowhere defines the meaning of these words, either by way of inclusion or exclusion, except insofar as this is done by the affirmative declaration that all persons born or naturalized, okay, in the United States and subject to the jurisdiction thereof, are citizens of the United States, and this is, in other respects, it must be interpreted in light of the common law, the principle in history in which were familiarly known to the framers of the Constitution. So that meant that the understanding of the history where the common law was derived from is what their understanding of how citizenship is supposed to be referred to and how it affects other people, okay? And framers of the Constitution knew a lot about the English common law and the English laws referring to the subjects that were subject to the king. They knew a whole lot about it because they insisted in overthrowing it, okay? It says the Constitution nowhere defines it, but nonetheless, it must be interpreted in the light, not in the darkness of the common law. Meaning, if it's not being used, then the common law is in the darkness, okay? If it's in the light, that means it's being used in lieu of the history in which the familiarity known to the framers of the Constitution, all right? Very important that you at least grasp that much of what this case is saying. And Smith versus Alabama delivered the judgment of the court and said, there is no common law of the United States in the sense of a national customary law, distinct from the common law of England as adopted by the several states, each for itself, apply as its local law. and is subject to such alterations as may be provided by its own statute. This is called reversion or conversion of law. Not meaning dissolve it, but amend it to make it better, to make it be able to be more comprehensible to the citizens, you know what I'm saying, in regard to those being born, not in that same in time and era as the law was written, but to fit the framework of the modern style of government that was adopted going all the way back to William the Conqueror. Okay? He built upon the English common law laid down by Alfred the Great. Okay? He confined to the Christ-like principles that laid down by King Edward the Peaceful. Okay? As the Good Shepherd. There is, however, one clear exception to the statement that there is no natural common law. The interpretation of the Constitution of the United States is necessarily influenced by the fact that its provisions are framed in the language of the English common law and are to be read in light of its history, brothers and sisters. Its history. The fundamental principles of that common law with regard to English nationality was birth within the allegiance, also called legality, obedience, faith, or power of the king. The principle embraced all persons born within the king's allegiance and subject to his protection. If you're not within that allegiance, power, and faith, especially obedience, then you're not under the king's protection as Prince Patriarch, father of the nation. Okay? Yes, my brothers and sisters, this still applies today. Children born in England of such aliens were therefore natural born subjects, but the children born within the realm of foreign ambassadors or the children of alien enemies born during within their hostile occupation, adverse possession, notorious open encroachment, all right, that's eminent domain, are not considered part of the king's dominion and were not natural born subjects because not born within the allegiance, the obedience, or the power, or as would be said in that day, within the jurisdiction of the king. Okay? Very important for you to understand how important this case is, i.e. the key to your salvation. All right? The laws of England and almost all civilized countries ascribe to each individual at his birth two distinct states or conditions, one by virtue of which he becomes the subject of some particular country, binding him by the tie of natural allegiance, and which may be called his political status. Another by virtue of which he has ascribed to him the character of a citizen of some particular country, as such and possessed of certain municipal rights and subject to certain obligations, which latter character is the civil status or condition of the individual and may be quite different from his political status. Did everyone understand that? So right now, 99% of you are in your civil status and not your political status. Why? Because there is no, in fact, no allegiance, no obedience, no obligation to the laws. Why? Because if you had an obligation, that would in turn govern the personal rights of that party. That is to say, the laws which determines his majority or minority, his marriage, his succession, his testacy, or intestacy. That means interstate, brothers and sisters. Interstate. If you're not in there, then it automatically streaks back to the owner, the grantor, the king. Very important, but you understand that the founding fathers knew that very well. Let's see. Let's scroll down in this case. Same case. Whoever watched this lesson, once you finish watching them, please leave me a comment of what you enjoyed about the lesson. Let's start. To what nation a person belongs is by the laws of all nations closely dependent upon descent. It is almost an universal rule that citizenship of the parent determines it, that of the father where the children are lawful, and where they are bastards, that of their mother, without regard to the place of birth. And that must necessarily be recognized as a correct canon, since nationality is in the essence dependent on descent. Y'all gonna like this one. Check it out. The framers of the Constitution were familiar with the distinction between Roman law and the feudal law, between obligation based on the territoriality and those based on the personal and individual character of origin. And there is nothing to show that in the matter of nationality that they intended to adhere to the principles derived from the regal government, which they had just existed and overthrown. We're talking about your founding fathers overthrowing that government that was there prior to the overthrowing of government, which, as this lecture articulates, this is a revolutionary breach of the English common law legal continuity of government. Okay? It's a breach. 14th Amendment, as it establishes, shows that there is in fact a breach because Section 2 of that relieved the framers of the Constitution of their obligation and duty. Okay? Yes, the 14th Amendment did that. Section 2. And Section 3. Let's look at that before we go back to the case. Representatives shall be apportioned under the 14th Amendment in regard to what Section 1 calls for, the protection of the emancipated people's life, liberty, as well as their property, and that it can't be taken from them by way of divestment without due process of law under the 14th Amendment. Okay? Pursuant to what? Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole numbers of persons in each state, excluding Indians not taxed. But whenever the right to vote of any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of a state, the members of the legislature thereof, is denied to any of the male inhabitants of such a state being 21 years of age and citizens of the United States are in any way abridged, except for participation in rebellion or other crimes on the basis of representation therein, should be reduced in the proportion where the numbers of such male citizens shall bear the whole number of male citizens 21 years of age in such state, meaning the age of accountability. Nor shall, according to Section 3, Any person shall be a senator or representative in Congress, or elector or president and vice president, or hold any office, civil or military, under the United States or under any state, whom having previously taken an oath as a member of that Congress. What Congress? The Congress established by the 14th Amendment. Okay? That was a new Congress that dissolved the oath. So I mean, any officer of the United States or a member of any state legislator or any executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof, by Congress made by a vote of 2/3 of each house, remove such disability. That disability was removed by the 14th Amendment as a result of the breach of the legal continuity of the English government, which protected the life, liberty, and pursuit of happiness of the subjects. As we just read in United States versus One Kim Ark, the true intent of the 14th Amendment. Okay? And Congress, under Section 5, had the power to appropriate the legislation to carry out the provisions thereof. Okay? Let's go back to United States versus One Kim Ark. So as we can see, the founding fathers understood the distinction between Roman law and feudal law. So they wasn't stupid, all right? And they definitely understand nationality versus naturalization, okay? They were nationals. Why? Because they overthrew the national government as established prior to the 14th Amendment, because at that time, the nationals were enslaved by the Fifth Amendment, which means that when you try to emancipate yourself, you were brought right back to the slaveholders. Okay? Very important for you to comprehend that. All right? Why? The case is going to say it. Manifestly. Manifest destiny. Okay? Manifestly denotes to the manifest destiny when the sovereignty of the crown was thrown off and the independent government established every rule of the common law, as what says Smith versus Alabama said, they all adopted the common law of England, and every statute of England obtaining in the colonies, they ain't talking about states now, in derogation of the principles of which the new government was founded, was abrogated. Okay? So manifestly, when the sovereignty of the legal continuity of the English crown was thrown off by way of breach. Why? Because according to the law, that government is still in place. Okay? That government is still functioning in 2025 under the legislative statute. Okay? And the protection on that legislative statute in regards to the sovereignty of the crown, which they claim to have thrown off by suppression. Okay? By suppression, I might add, it says here, the states for all national purposes embraced in the Constitution became the state for all national purposes embraced in the Constitution became one, united under the same sovereign authority and governed by the same laws, but they retained their jurisdiction over all persons and things within their territorial limits, except which were surrendered to the general government or restrained by the Constitution. This you must listen to. They retained the jurisdiction over all persons that were emancipated by the 14th, 13th Amendment and became citizens by the 14th Amendment as a result of what? Let's read further. They retained their jurisdiction over all persons and things within the territorial limits except which was surrendered to the general government or restrained by the Constitution, and protection to life, liberty, and property rested primarily with them. That same, in the 14th Amendment, let's go back to it. All persons born on the outside of the United States except to the jurisdiction thereof, and all citizens of the United States and the states where they reside. No state shall make or enforce any law which shall abridge the privileges or amenities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law, nor deny any person within the jurisdiction the equal protection of law. So if that's what that said under the 14th Amendment, and it was talking about everything after Section 2, prior to that protection under Section 1 of the 14th Amendment, then what the hell did they do according to United States versus 1 Kim Ark? Because let's read it again. The state, for all national purposes, embracing the Constitution, became one United States under the same sovereignty, authority, and governed by the same laws, but they retained their jurisdiction over all persons and things within their territorial limits, except which were surrendered to the general government or restrained by the Constitution and protection to life, liberty, and property rested primarily with them. Now, this case is in what? In 1898. Okay? This case was in 1898. The 14th Amendment was passed in let's go to it. 1898. Did you hear that, brothers and sisters? 1898. United versus Joachim Ark says in 1898. The 14th Amendment was created in what year? That's what I meant to look up. That's what I meant to look up. What year was that created? 14th Amendment. Let me just look that up. 14th Amendment. (1868). So the 14th Amendment was created in 1868, right? 1868, right? Now we're reading in United States versus 1 Kim Ark, okay, in 1898 case, and the folk rights, which is life, liberty, and property, based upon what the 14th Amendment said in 1868, all right, they now took for themselves. It wasn't for them, it was for who? The emancipated slaves. Okay? It was for the emancipated slaves, and we clearly see, according to the 14th Amendment, 1898, they took it for themselves. Now, how did they do that? Somebody please tell me. How did they do that? Anybody got any answers? Life, liberty, and property rested prominently with them, so far as the just commune or folk right related to the rights of persons was concerned. The colonies regarded it as what? Their birthright, and adopted such parts of it as they found applicable to their conditions. That's stealing, that's theft. That's theft right there, brothers and sisters. They became sovereign and independent states, and when the republic was created, each of the 13 states had its own local usage, custom, and common law, while in respect to the national government, there necessarily was no general, independent, and separate common law of the United States, nor has there ever been. The jura corona, including therein the obligation of allegiance, that the extent to which there ever was applicable in this country, depending on circumstances, and would seem quite clear that the rule-making locality of birth and criterion of citizenship, because creating a permanent tie of allegiance, no more survived the American Revolution than the same rule survived the French Revolution. Okay? That's very, very important, especially in regards to the framers of the Constitution understood the difference between Roman law and what they said feudal law. Okay? Roman law and feudal law. That's very important because they assisted in overthrowing All right, the law that was there prior to them, and the law that was there prior to them was the feudal law. Okay, and we know when you go to feudal law, you got to go into English feudal history, which we're going to now. Okay, so the framers admitted that based upon what Section 1 protected in lieu of the emancipated people, which were not black people, which were not African Americans, were not Moors, etc. They were English, Anglo-Saxon, and according to the calendar, the only calendar at that time when these Anglo-Saxons were ruling was the Berber calendar. That's why we call themselves Berbers. We know Berber means free man, okay? And when we were emancipated as freedmen, which was a derivative of that which was just before us being free, which is called freemen, which goes back to the time of the Doomsday Book, which is according to Anglo-Saxon law. The Doomsday Book, or the Last Judgment, is no different than what we call folk right. Okay? Folk right law. Anglo-Saxon law is called folk right law, and we understand that the framers stole it. They took it, and it was not for them. It was not for them, brothers and sisters. Let's look at it. Let's look at feudal law. Feudal land tenure. You say feudal law, then you got to go into feudal land tenure, which the colonists are automatically said they were aware of. They knew this history. Okay? Very important for you to understand that, where I'm about to go with this. All right? This is not just for educational purposes, my brothers and sisters. This is for legal purposes as well. And you don't need an attorney because you are more have more authority than the power of attorney. Okay? You are the heir. You are the beneficiary. Okay? It is your right to petition either the king or what the king put in place to protect your right in lieu of life, liberty, and property. That's your representative. All right? Without that right to vote, without that voice, you have nothing. Okay? Feudal land tenure. Since they knew about it, how we know it? Let's prove it. That they knew about feudal land tenure. Let's prove it. This is one of the defendants in the case before the appellate court. Let's prove it, that they know about it. History and background of feudalism. Because New Jersey was formerly a colony of the Crown of England, the history of development of our entire legal system, including our system of land ownership, has its roots in England. For our purpose in development of land ownership, it began with the successful invasion of England by the Normans in the year 1066 under the leadership of William the Conqueror. William I introduced the feudal system to England. Feudalism is based upon the concept that all land is held whether immediately or mediately by the sovereign. In other words, all land is owned by the king, and all others having an estate and interest in land ultimately derive their interest from what? The king. Let's move a little further. Edward I, as noted above, feudal tenures were to some extent transferable. During the reign of Edward I, the practice of transfer of states through a device known as subrogation became widespread. The economic burden imposed tenants by the feudal obligation, and as a result of that, they all looked to their king for remedy. Okay? They looked to the king for remedy. Right here, Queen of Pentoris is right here. Now, they know about this, okay? The state know about it, and the other party who's also a respondent or defendant in the case knows about it because this is from your own teacher manual. Statue of Queen of Pentoris. Since the incidents were a great economic value to the overlord, they naturally turned to the king for assistance. His response was the enactment of the Statute Quinipetoris Terranum concerning His Majesty's laws of buying and selling of the king's land. The name is law is taken from the opening word, meaning whereas purchaser of the land. Buyer beware. Okay? Buyer beware. Okay? Let's look at this a little bit further. Let's go ahead. Right here. Right here, brothers and sisters. Right here. Decline of collapse of feudal system. Decline and collapse of the feudal system, i.e., feudal land tenure, as noted above. One of the respondents or defendants in the case right before the appellate court, as a result of them knowing this information, where did you get it from? All right? And we go to the defendant's brief cross motion on page 30. They mention New Jersey Revised Statute 46-2, which shows you that the legal continuity of the crown, or which the king represents the crown, that shows you that the statute of tenures were in effect, which abolished all feudal tenures, which was an act created by Henry VIII in 1660. Okay? All right? Decline and collapse of the feudal system, as noted above, was by the Statute Quinipetoris, marked the beginning of the end of the feudal system. A decline was abetted by changing social and economic conditions, as well as by certain legislative enactments. For example, by the Statute of Tenures, most feudal obligations were converted into free and common soakage, which amounted in practice to payment of rents in cash. Did you hear that? Did you hear that? In New Jersey, the Statute Quinipetoris was reenacted as part of the statutory scheme regarding real estate. While this law may seem archaic and unnecessary in contemporary society, it must be viewed in the context of a legislative scheme which sought to eradicate the last vestige of feudalism in New Jersey, which was started by William the Conqueror, known as feudal tenure versus land tenure, and to prevent its establishment of some future present date. Accordingly, other sections of New Jersey Revised Statute Title 46 abolished feudal tenure to eliminate feudal services and instances in favor of free and common soakage, and to provide that the conveyance from the state should be allodial and not feudal in nature. It's true that the feudal system never really took hold in America because it was dying out in England. By the time colonization occurred, nevertheless, people still made claims in it, such as what? King Charles II, by way intercharted the Duke of York on March 12, 1664, which was dissolved. Okay? Which was dissolved. Let's read a little further. They mentioned Title 46, didn't they? Didn't they say that? Let's read a little more. Conveyance under feudal system, the importance of season. Under the feudal system, transfers were accomplished by a ceremony known as lottery of season. You hear that? Ceremonial, an ancient archaic usage of customs that only denotes to those who are heirs. It was known as lottery of season, whereas the grantor, which would be the king, not some real estate agent that sells land that don't belong to them, through what we call average possession, which is the process used under eminent domain, through what we call prescription of sovereignty, which is land acquisition of sovereignty, through what we call eminent domain, which allows for average possession, which is called hostile take of land that does not belong to you. So under the feudal system, transfer were accomplished by a ceremonial known as lottery of season, and it was legislative enacted pursuant to that ceremony that's still effective today in solemnity, which clearly denotes to a process which says that when the grantee went physically onto the land, it didn't say the grantor, it says the grantee went physically onto the land and performed as a prescribed. You see those statutes right there? Where they at? Let me go back. See these statutes right here. 4th country, that's 1. 4th country, that's 2. 4th country, that's 4. And 4th country, that's 6. These are all the laws governing the legal continuity of our government, which are still active in this present day. They know it, and they suppressed it. Let's look at it. So it says, a ceremonial ritual known as Laria season. Season at the early common law was synonymous with possession. However, season was more than a legal principle. It was also a metaphysical concept arising from the Lord's moral duty to protect the tenant and the tenant's moral duty of loyalty to his overlord. Did you hear that, brothers and sisters? Let's look at it. Later development. Later development, when enactment of the statute of uses, Laria season was no longer necessary to transfer ownership of land. I repeat, later development, when the enactment of the statute of uses, Laria season was no longer necessary to transfer ownership of land. This vastly simplified the means of conveyancing. Transfers by deed or bargain and sale became common at this time, meaning by way of deed. Voluntary alienation of land by what we call the statutes of wills. Okay? So there you have it right there. It's no different than if you read it word for word in the legislative intent in the statute. Let's read it. The same language you just read is right here. New Jersey Revised Statute 4623-6, it says that the land is allodial prior and after July 4th, 1766. Right here. All gift grants or conveyances made prior to and after July 4th, 1776 of any estate of inheritance by a letter patent under the great seal of this state or any other manner by the state, by the legislature thereof, or by commissioner or agents or forfeit of the state, or by any other lawful competent authority under the state, shall be and remain allodial and not feudal, i.e. feudal land tenure, all right, and shall forever be and continue in free imperial allodium, only forever discharge of all feudal tenures and the instance thereof, and all otherwise in all others whatsoever. Meaning that any other process other than what's called by way of the legislative intent is notwithstanding. Okay? That is the legislative enactment of the reception statutes of parliamentary enactments. Okay? Let's go here. Let's go even further. You can look it up yourselves. Title 46. Title 46 going through, that's 1. Again. Have been abolished by the filial tenure abolition 1660. Of 1660 by Henry VIII. Okay? This is this act right here. The filial tenure estates and the instance thereof taken away, discharged, and abolished from March 12, 1664. That's the charter given to the proprietors George Corrett and John Berkeley. Before it was called New Jersey, it was called Jersey, flying in a whole other flag other than the flag you see now. Okay? So the land was abolished. That means there's no more feudal land tenures. If there's going to be some type of tenure, it's not feudal, because feudal involves a tax, pretty much what you have now. Why? Because the land is allodial based upon 4623-6. If the land is allodial, then there are no feudal tenures as established. Why? Because the king has it, because it is ceded to the upon the let's read here. 4623-2, still alive in 2024. This shows you that there is in fact a breach in the crown government and the legal continuity of that government in regards to the obligation that not just the king has, but you as an heir or a subject has, in regards to making sure that they, as representatives pertaining to Section 2 of the 14th Amendment, protect your rights according to Section 1 of the 14th Amendment, which was implemented and apportionment by the Congress in Section 5. Okay? And all the other debts under Section 4 of the 14th Amendment, we're not responsible for. Because at that time, we were debtors. So it says here, the tenures of honors and manors and lands and tenements or hereditaments or estates of inheritance at the common law, as we see in the United States versus 1 Kim Ark, held either by the King of England or any other person acting as the King of England, restore or preserving that body of politics, i.e., that legal continuity of the corporate powers that were incorporated based upon the sovereign grant under 16:1-28, rights staying under the charge of Great Britain, save from repeal, and act to incorporate trustees of religious society for property held in corporation in place thereof. So if the founding fathers did not incorporate it under 16:1-28, then they are in breach of what the second and third and fourth section of the 14th Amendment says. They're in total breach because the legislative intent is right here. We're reading an intent. There are no more fiddle tingers here. It's only land tingers, and the only person that could give that land tinger is the King of England as a result of what we call folk right. Folk right is what William the Conqueror called Doomsday Book, or the last day of judgment, because he kept a record of all the land tingers that were there prior to the fiddle tinger that he established. That goes back to what we call the folk right, which is going to United versus 1 Kim Ark. They clearly said that what? They took it as their own. Let's look at it. Go back to it. Where's it at? Right here. They overthrow the crown government, and the crown government was a government that protected the inheritance, which involved, as I said, the land. Okay? It involved the land. They admitted it straight out. Right here. The state, for all natural purposes, embraced in the Constitution, became one, united under the same sovereign, de facto, I might add, and governed by the same law by which they retained their jurisdiction over all persons and things within their territorial limits, except which were surrendered by the general government or restrained by that Constitution. And protection to life, liberty, and property rested primarily with them. So it was their obligation as trustees to make sure that that property that was protected when the life and liberty was restored to the emancipated slave as a result of the just commune or folk right that actually belonged to them, which was a birthright known as just sanguineous. Okay? Very important for you to understand that. William the Conqueror understood this as well. Why? Because let's look at it. This folk right is nothing but what we call Anglo-Saxon law. Okay? Anglo-Saxon law is called folk right, my brothers and sisters. Anglo-Saxon law. Listen, y'all. Before Christianization, native inhabitants of England were Celtic Britons. The unwritten Celtic laws were learned and preserved by the Druids. All right. Preserved by the Druids, who, in addition to their rigorous religious role, also acted as judges. After the Roman conquest of Britain in the 1st century, and it said the framers understood Roman law and feudalism. Didn't they say that? And United versus 1 Kim Ark, they understood that history as Roman conquest of Britain In the first century, Roman law was operative, at least concerning Roman citizens, but the Roman legal system disappeared after the Roman left the island in the 5th century. So we're still talking about that same island that the Romans invaded, later William conquered, okay, who established Fighting. In the 5th century, the Anglo-Saxons migrated from continental Europe and established several Anglo-Saxon kingdoms. These had their own legal traditions based in, as they presumed to be Germanic law, which is a lie because we don't speak German. That owed little, if anything, to Celtic or Roman influence. Anglo-Saxon law largely derived from unwritten custom termed folk right, i.e., right or justice of what? Everybody said of the people. Of the people. The folk right was our law. Okay? Very important. Alfred the Great encoded them in what we call the Doom Book. Okay? Following the Christianization of Anglo-Saxon, written law, code, or dooms were produced. Christian clergy brought with them the art of letter writing and literacy. The oldest Anglo-Saxon law code, especially from Kent and Wessex, reveals a close affinity to Germanic law, that which is a lie. First written Anglo-Saxon law was issued around 600 BC by Althebert of Kent, written in the 8th century of Venerable Bede, comments. This like refers to Romanized people such as the Franks, whose Salic law was codified by Clovis I, okay, who were not descended down like the Anglo-Saxon. We must understand that. Folk right could be broken or modified by special law or special grant, and the fountain of such privileges was the royal power. Alteration exceptions were, as a matter of fact, suggested by the interested parties themselves, and chiefly by who? Everybody said the church. Thus, a privileged land tenure was created by what we call bookland. What is bookland? Let's look at it. Bookland was a type of land tenure under Anglo-Saxon law referred to the land that was vested by charter. You hear that, brothers and sisters? By charter. All right? Don't play with the king. By charter. Oh, y'all don't, boy. Let's get it. And we go back to 1911 Encyclopedia Britannica. The government of the Berbers was called what? Wittenmar. And Wittenmar means what? Wise counsel. Okay? Witten. All right? Wise counsel. 1911 Encyclopedia Britannica. I ain't even got to go there. All right, so since we're there, let's go back to feudal tenure. Okay? High Middle Ages. So folk right or bookland or land tenure is totally different from feudal tenure. Okay? Totally different. Feudal land tenure in England, ancient past, large parts of rims were unoccupied, okay? Meaning that there are no land tenures. If there's no land tenures, there's no conveyance of land. If there's no land conveyance of land, that means that the land is still vacant, which means it's a lodio. Okay? It is a lodio, and if the land is lodio, then that speaks right to New Jersey Revised Statute Force. It's going to do that. See, so how is this stuff going on the land when the statute clearly says that it should be unoccupied? And William the Conqueror kept a log of it. It's called the Doomsday Book, okay? It's called the Doomsday Book, the Day of Judgment, okay? Very important. In England, ancient past, large parts of the rim were unoccupied and owned as a lodio title. The landowners simply cooperated with the king out of the mutual interest instead of legal obligation. It was not until the Norman conquest where William the Conqueror declared himself to be the sole de facto lodio owner of the entire rim that land tenure changed drastically, and William's kingdom, the common exchange and sale of land became restricted, and landowners were made to provide a service to the lord. No land without a lord. Okay? No land without a lord. This brings into what we call tenants in chief. Okay? Tenants in chief. Y'all better listen to me. Let's get it. The system failed because the assessment of knights' fiefs became impossible to maintain, and feudal states retained the same wealth and population as with the first enfeoffment, i.e. conveyance. With the result of that, Lord provided only small numbers of the knights whom was actually able to muster. Another issue was the practice of a violation of Queen Praetorius as a result of the Dunce Condition of Bus, which was passed by Edward I in regards to the inheritance known as Crown Land that was strictly, inclusively, and exclusively for the emancipated people of English, okay, now known as black people or African Americans. This became unpopular among superior lords and was banned, and Edward I issued a edict called Queen Praetorius, a law against substitution. Okay, very important for you to understand that. During the course of the late middle period, night services can be replaced by the tingers of soakage. You hear that? Soakage. This brought on what we call the Tinker Abolition Act of 1660, which declared that all land was to be held by soakers, tingers, ending the feudal tinker. Let's look at that, brothers and sisters. Tinker Abolition Act of 1066, passed by who? Henry VIII of the House of Lancaster. I'm pardon myself, not Henry VIII, Charles II. Okay, my bad, Charles II. Let's look at that. Before we look at that, let's see how this act was reincorporated in New Jersey Revised Statutes. First, it's going to do that's 1, 2, 3, and 4, 5, and 6. Let's look at it. Right here. Let's act AI first. I wanted to make sure that I knew what I was talking about, so I asked AI about the Tinker Abolition Act, which ended all federal tingers at the reign of a German king, because Carl II had some German blood in him. Okay, when really the English don't have German blood. It says here, AI overview. Yes, the core principle of the Tinker Abolition Act of 1660 is incorporated into New Jersey Revised Statute 4623-2. Did y'all hear that? How New Jersey statute reflects the 1660 Act. While not a direct codification, New Jersey Statute Annotated, which is the New Jersey Revised Statute, one and the same, serves the same function as the English Tinker Abolition Act. It abolished feudal-style land tenure and replaced it with the modern system of ownership. What else? How the New Jersey statute reflects the 1660 Act. While not a direct codification, I didn't want to go there. Right. Establishing free and common soakage. This is what this Tinker Abolition Act says. To establish free and common soakage, it declares that these former tingers were converted into homelands by freeing common soakage. This meant that land is held by paying rent or a nominal services, which essentially equates to the modern concept of fee simple, where ownership is absolute and not subject to any feudal duties. Linked to earlier law. The statute referenced an earlier New Jersey Act formed from 1795, which itself establishes that the modern form of land tenure in this state. This shows a direct line of legal history from the oldest feudal system to New Jersey's current property law. Did you hear that? So I just showed you the link, brothers and sisters. I just showed you the link. Let's go by. Let's go back and read the Tinker Abolition Act. Because as it said it, they are one and the same. All right. Now we know Tinker Abolition Act was the abolition of feudal tenure, which was brought by William the Conqueror. All right, as a result of what we call feudalism. All right, these are the provisions right here. Nothing has changed. All right. It says the act was partly enforced in the United Kingdom at the end of 2010 through only Section 4. It says that in all tenures hereafter is to be created by the King's Majesty, his heirs, or successor. What is the name of our nonprofit? The King, heirs, and successors. That's what we're called. The Third Convenient Church of England, King, heirs, and successors. So it says an act and that all tenures hereafter to be created by the King's Majesty, his heirs and successors upon any gift or grant of any man's land, tenement, or heritage of any estate of inheritance at the common law should be in free and common soakage, and should be adjudged to be in free and common soakage only, and not by knight service or incapacity, and to be discharged of all board ships, value, forfeiture, marriage, library, requirement, season, ouster, and lemain, ad perfias, chevalier, and pure familiar. Any law, statute, or reversionary reservation to contrary thereof in any wise is what? Notwithstanding. Why is this important? Because it's right here, alive and well. Right here. Right here. We just read it. Forces going through -1 is the Tenure Abolition Act reenacted in reenacted by King George III. Right? Federal tenure is right here. Why is it abolished? Because the land is allodial. As Forces going through -6 says. If it's allodial, that meant that it's a she. Right here. King of England, body politics, or corporate. If the king ain't there, that don't mean the body politics ain't running and functioning. It's just dormant, okay? Why? Because it was prophesied for the king to come into possession of his land. He can't take possession until he come into possession, okay? And that's through what we call the finding of office. Jones versus Freeman said that. Let's look at that. If it's not that, it's Gouverneur versus Gouverneur case. I'm not even going to dwell with that. Let's go back here. In closing. Okay. Avalon Project. These are the words of William the Conqueror. Okay? Words of William the Conqueror. Before we do that, let me just make this one more connection. In closing, Anglo-Saxon law is the same law that William the Conqueror practiced, which is a law protecting the folk right of the emancipated slaves, which was stolen by the founding fathers, as admitted in the United States v. 1 Kamara. Anglo-Saxon law, meaning law, lagu, law, and doom, decree, judgment. You hear that? Law, lagu, meaning law, and doom, decree, or judgment. So that means that the Doomsday Book, because if you look at the Doomsday Book, what was it called? Let's look at it. So that means the law books, the records, brothers and sisters. The Doomsday Book is the law of doom, the law, okay? We talked about it in my last lesson that I did prior to this one. So if you don't understand, please go back and review that. So it says, Doomsday Book, spelling Doomsday Book, is a manuscript known as what they call the Great Survey, okay? The Great Survey, the name. To the English who held the book in awe, it became known as the Doomsday Book, an allusion to the Last Judgment and specific reference to the definitive character of the record. The word doom was the usual Old English term for law or judgment, Anglo-Saxon law. Lagu law and doom judgment, my brothers and sisters, all passed by King Henry II, the son of Godfrey V, Count of Anjou, King of Jerusalem. Okay? Son of Folk, ruler of Jerusalem. So, with that being said, let's read what William the Conqueror said. Okay? In closing. The statutes of William the Conqueror in reference to the Doomsday Book, or the Day of Judgment. Statute of William the Conqueror. Here is shown what William the King of England, together with his prince, has established since the conquest of England. We say conquest, you're talking about prescription of sovereignty. We're talking about acquisition, land acquisition of sovereignty. You're talking about eminent domain. You're talking about adverse possession. Okay? William the Conqueror understood that, but nonetheless, he still held up the law. How we know it? Let's read it for ourselves. Here is shown what William, the King of the English, even though he was the de facto king, together with his princes, which established since the conquest of England. No different than what the House of Stuart did, no different than what the Poppetiers did, no different than what the colonists did, no different than what the states did. Okay? First, Ten Commandments. Mosaico. First, that above all things, he wishes one God to lie venerated throughout his whole kingdom, one face of Christ always to be kept inviolate, peace and security to be observed between the English and the Normans. Did you hear that? Did you hear that? 2, we decree also that every free man shall affirm by compact and an oath that within and without England he desires to be faithful to King William, to preserve with him his land, his honors, with all fidelity, and first to defend him against his enemies. 3, I will moreover that all men who I have brought with me, or whom have come after me, shall be in my peace and quiet. Meaning that don't stir up no mess, don't cause no disrupt, don't cause no war, don't cause no conflict, don't breach any law that William the Conqueror was upholding. He didn't create new law, he just upheld the law, what's called the Doom Law, Doom Book, Law of Judgment. And if one of them shall be slain, the Lord of his murderer shall seize him within 5 days, if he can. But if not, he shall begin with to pay to me 46 marks of silver, as long as his possession shall hold out. But when the possession of the Lord of that man are at the end, the whole 100 county, shire, and with the slaying took place, shall pay in common what remains due. Okay? 4. And every Frenchman who in the time of my relative, and every Frenchman who in the time of my relative, King Edward the Confessor, brothers and sisters, was a sharer in England of the customs of the English, not the Normans, but of the English, shall pay accordingly to the law of the English what they themselves call unlet or enclosed. This decree has been confirmed in the city of Gloucester, brothers and sisters. 5. We forbid also that any live cattle be sold or bought for money except within the cities, and this before 3 faithful witnesses, nor even anything owed without a surety and warranty. But if he do otherwise, he shall pay and shall afterward pay a fine, meaning that all things must have a surety. This is called what we call it in real estate law. It's called title insurance. Okay? Protection. 6. It was also decreed that if a Frenchman summoned an Englishman to perjury or murder, theft, homicide, or ran as the English call evident rape, which cannot be denied, the Englishman shall defend himself as he prefers, either through the ordained ordeal of iron or through wage or battle. This was what you done before we had the court system. Okay? But if an Englishman be infirm, he shall find another who will do it for him. All right, it's a friendly council. If one of them shall be vanquished, he shall pay a fine of 40 shillings to the king. If an Englishman summons a Frenchman and be unwilling to prove his charge by judgment or by ways of battle, I will nevertheless that a Frenchman purge himself by informal oath. 7. This also I command and will that all shall hold and keep the laws of Edward the king with regards to their lands and with regard to all their possessions, though the provisions being added which I have made for the utility of what? Everyone saying? The English people. Every man who wishes to be considered a free man. You hear that? A free man shall have a surety that his surety may hold him and hand him over to the justice if offended in any way. And if any such one escape, his surety shall see to it without making difficulties. They pay what is charged against him, and that they cleared themselves of having known of any fault in the matters of his escape. This is the Fifth Amendment, y'all. The hundreds and counties shall be made to answer as our predecessors decreed, and those that are out of right to come and are unwilling to appear shall be summoned once. It's called an order to show cause. It's called a cor warranto. And if a second time they are unwilling to appear, one ox shall be taken from them, and they shall be summoned a third time. If they do not come the third time, an ox shall be taken. But if they do not come the fourth time, they shall be forfeited from all goods, and that man who was unwilling to come, the extent of the charge against him, kept gets, also called it. Besides, this is a fine to the king. 9. In closing, I forbid any one to sell a man beyond the limits of his country, on the penalty of fine in full to me. 10. I forbid that anyone be killed or hung for any fault, but his eyes should be torn out of his testicle and his testicles cut out. And this command shall not be violated on the penalty or fine in full to me. There you have it. Henderson's note. The laws of William the Conqueror is probably the sum of substance of all enactments made by that sovereign. Especially interesting are the references of 6 to the wage of battle, the first mention of that institution in English law, and the law against capital punishment, Article 10. Okay? So there you have it, brothers and sisters. Who else? What else I'm going to close out? Right here. Let's close out on Jones versus Freeman. Jones versus Freeman in 19. I forgot what year this was. All right. The basic idea of a state constitution, we're talking about Article 14th Amendment and Section 1, Section 2, Section 3, Section 4, and Section 5. In regards to what Jones and Freeman said, based upon the judgment that was prepared and adhered to by those who were the overseers of the time when this day was to come to fruition, okay, which is now. The basic idea of the state constitution is a popular representative government, the officers being mere agents, not rulers of the people. One where no man is so high to be above the constitution and no one so low to be beneath its protection, okay? All stemming from United versus 1 Kim Ark, okay? Should the illuminating precedent of history ever be forgotten? Should the landmarks of the fathers and lighthouse planted upon the shores upon which other states be floundered, be turned away? Are the secrets of that old doomsday book of the Anglo-Saxons to be read in vain? You hear that, y'all? Are the secrets, the suppressed secrets of the old doomsday books of the Anglo-Saxons to be read in vain? Or as part of the administration of right and justice should speedy and certain remedy be afforded for every wrong? No, if you don't know it, but yes, if you do. Okay? If you know the law, then it won't be taken in vain. If you don't know the law, then it will be taken in vain as a result of 14th Amendment, Section 1, Section 2, Section 3, Section 4, and Section 5, my brothers and sisters. And with that, I love you all, and I hope that you will come to the understanding of what is required for every national concerning their birthright and inheritance that will surely follow once office is found on behalf of the king and matters of his treatment. And with that, I'm going to greet you as I always have greeted you. And that will be in peace,